Frank, how are you doing?
Good.
You're busy with the consultation?
Yes, that's what you're working on right now.
Yes, I'll take a look, and I'm hoping to join virtually next week, isn't it? Yeah.
Yeah, it's next week. This on Tuesday, Wednesday.
27th starts 27th through to the 29th, is it? Is it 3 days of public consultation?
Yes.
A bit different from when I was there physically doing it, yeah.
Yeah, now you can do them virtually.
I'd rather be there physically. To be honest, I would rather fly and work in Africa for a week than to continue to do these calls. I think these kind of things are more exhausting than getting on a plane and coming and meeting you all, to be honest. And anyway,
yeah,
coming to Africa is always nice.
True. Killing towards the same stone, safari and work.
Yeah.
All right, we're just going to start now. Hi, everyone. You're welcome to the webinar today. Thank you very much for joining us. We're in our midst today. We have really amazing line of speakers who are going to be sharing their experience about what we've seen in Africa so far in the past 2 decades. Just by way of quick introduction, data protection in Africa started with the enactment of the data protection law in Cape Verde in 2001. And from then, we've seen quite a number of African countries enact their own data protection laws. And between the same period, we've seen quite a number of African countries too set up their data protection authorities. And we're beginning to see data protection beginning to gain ground in Africa, shaping policies and also influencing how some of things that have been done on the continent has been carried out. But beyond the fancy of having a law, or sometimes maybe having a data protection authority, there are a number of challenges that have equally plagued data protection in Africa. And of course, some of these challenges are some of the things we'll be getting into today, and our panelists will be helping us to dissect some of these issues. Beyond the challenges also, there have been so many positives in between that. A couple of laudable innovations, a couple of laudable achievements, let me put it that way, that we've seen. In spite of that, we're also looking to a situation where we can continue to make that progress, continue to make that improvement. And of course, maybe if we look at the next decade, we'll begin to see things maybe completely differently. So, and today, to help us get into some of these issues, we have the privilege of being in the midst of a couple of amazing people that I'm in awe of the kind of work they've done. And these are people I actually look forward to personally. And I would allow my colleague, allow my host today, Nordin, to come in briefly to do some sort of introduction. Then after that brief introduction, we'll take things up from here quickly. Thank you again for joining us. Over to you, Nuruddin.
All right, thank you very much, Ridwan. I don't know if you can hear me loud and clear.
Yeah, we're good.
Perfect. Thank you for that swift introduction, Ridwan. I'm opportune to actually introduce our panelists today on topic of 2 decades of data protection in Africa. I mean, we start with ladies first, right? So permit me to do that. So I'm going to start with Teki, right? Teki is an ICT and telecom lawyer, and also a privacy and data protection consultant, and also a senior partner at the law firm based in Accra, Ghana. She's the founder and executive director of the Digital Rights Hub. I'm sure everyone is aware of Africa Digital Rights Hub. I mean, if you're not aware, I would suggest you probably go on Twitter and see the amazing. She's the founder of Digital Rights Hub, Africa Digital Rights Hub, a member of the UN Global Pulse Privacy Advisory Group, and a non-resident fellow at the Center for Global Development. Previously, she had worked for government of Ghana in development of several key legislations for ICT, including Data Protection Act of 2021. Ghana is one of the also countries that are being foremost in terms of releasing their Data Protection Act. And she has also worked in a number of other frameworks and legislative instruments for the government. She was the first executive director at the Data Protection Commission of Ghana, which is a laudable achievement by all rights. She holds an LLM in information technology, telecommunications law from the University of Strathclyde, Glasgow, Scotland, and a Bachelor of Arts in Law and Political Science from the University of Ghana, Legon, Accra. Join me, everyone, actually welcoming Teki for the discussion today. Thank you very much, Teki, for honoring us. Like I said, I think I'll still stick with my ladies first approach. Apologies to Pat and Francis. I'm going to come right to you guys very soon, right? Danielle is an attorney at law and the managing partner of Moukouri and Partners, a law firm recognized for pioneering technology law practice in Cameroon and Central Africa, and is ranked by Chambers and Partners, the Legal 500, and Lex 4, and a number of other ranking organizations. She specializes in corporate law and technology law and has acted as an intellectual property counsel in leading law firms in Cameroon, Nigeria, and also South Africa. She has obtained professional certifications from the World Intellectual Property Organization, WIPO, and the African Intellectual Property Organization, OAIP. She is trained in artificial intelligence and legal tech in Japan and a computer science at the Harvard University, USA. She advises on financial technology, blockchain, cryptocurrency, and data protection, which will be centered around most of our discussions today. She's a member of the Cameroon Bar Association and the Nigerian Bar Association and the American Bar Association. I mean, those are like 3 different bar associations. So she's a well-rounded lawyer across Africa. Thank you very much, Danielle, for joining us today. I'll go to my friend, Francis. Before I come to you, I think I need to be biased here. Pat is actually a very good friend, so permit me to go to him first. Pat is a data protection and privacy professional, managing director of Privacy Matters Limited, has over 24 years of experience in data protection, privacy, telecommunication, information security, interception and disclosure law, data for development, mobile identity, in addition to regulatory policies in the field of mobile and internet sectors. Pat is passionate about the role of technology and data and the value, opportunities, and benefits they bring to individual, community, and to the society. He is equally passionate about mitigating risks to individuals and communities that can arise through digital connectivity, services, and data. I mean, I remember Pat always saying, keep it human. I'm sure that's going to come up in our conversations today. Pat has a degree in social anthropology and development and also data protection and information security audit qualification. He has served on the International Standard Organization, ISO, the Privacy Steering Committee, and is a member of the BCS, the British Computer Society. He's also a member, just like Teki, of the UN Global Pulse Privacy Advisory Group on big data and sits on the International Advisory Board for Adaptive Security and Privacy Project, and was a member of the Eternal Ethics Panel for leading mobile operator on the use of big data for development. Pat was made a Privacy by Design ambassador by the Ontario Information and Privacy Commissioner in 2013. He's a current member of the Advisory Council of Defend Digital Me, an NGO leading on the protection of privacy for children in education in England. That seems like a mouthful for all the profiles for
you can skip
everybody
all that.
about today.
That's too much.
Thank you. Thank you very much, Pat, for joining us today. And last but not the least, Francis. Permit me to also do that. Francis is a technology law and policy analyst based in Nairobi. It speaks to the well-rounded panelists which we have today from all over the world and all over Africa. He's an advocate of the High Court of Kenya and a certified information privacy professional Europe. That's the CIPPE. His most recent work investigates how COVID-19 measures announced by the government of Kenya affected digital rights of people. His current research interests are in data protection, compliance, privacy by design, commercial concept, freedom of expression, online, and e-commerce in Africa. Join me, everyone, also welcoming Francis to the panel today. Ridwan, I think I'll hand over to you so we can get the ball rolling. Thank you very much, everyone.
All right. Thank you very much, Noreen, again for doing that introduction. And like I said earlier, there's going to be so much to talk about today, and hopefully time will permit us to go into details as much as we'd really love to. All right, to get a conversation, to start a conversation today, I'm going to start with you, Teki. And I'm starting with you because you have a very interesting profile. You straddle between research, straddle between playing on the side of the regulator, you're a consultant, and I mean, all shade of everything as far as data protection is concerned. So maybe the next question I'll ask you is, maybe you've been playing with tools too. So maybe you have something you have up your sleeves as far as relates to privacy engineering. So, but to get a question, so what I'm going to start with is 2 decades of data protection in Africa. We started from when we had the law in Cape Verde in 2001. First decade, we saw the number of laws that came into place, Seychelles, Senegal, those first few countries in 2008, 2003 that made their laws. In the second decade, we had more laws, of course, that also followed with establishments of quite a number of data protection authorities. I think during our last mapping that we did, we have about 19 of them or 17, depending on how we choose to identify them. So without wasting time, what would, if you're going to just speak about those first 2 decades, how would you describe it? And I'm saying that because also very early stage or very early part of the second decade, you acted as the executive director of the Ghanaian Data Protection, literally setting up, establishing the Data Protection Authority in Ghana. So how would you describe the first 2 decades? Yeah, thank you.
Thank you, Ridwan, and thank you, Tech Hive Advisory, for bringing me on board. How would I describe the last 2 decades for data protection? I would say that when it comes to legislations, we have made progress, obviously. And as you rightly narrated, from 2001, we realized that the first decade we had a few institutions coming in, and in the last decade, we've seen a very significant increase. And a lot of these issues are stemming from a number of things, which I would say, fortunately or unfortunately, for Africans, we are not, we're not excused from. And what is really driving what you've seen in the last decade is not just an issue of just adopting laws, but because of the nature of the technologies that we constantly find ourselves using, even those of us on the continent, and the invasive nature of those technologies, as well as the concerns around the issues of how these technologies are going to impact people, especially people whose information are shared using those platforms. So that is one of the biggest drivers over the last decade. Another big driver over the last decade has been the donor communities. So a lot of them are giving grants for particular activities, right? If you look at institutions such as the World Bank and the rest, where they are giving loans to governments to undertake, whether it's digital ID and all of that, there's been requests to have stronger systems, whether it's legal systems or institutional parameters, to ensure that information is adequately protected. So we also see a drive in that. In as much as we've seen this progress, and I think that we've been very slow. We have been very slow also in realizing the vision of these laws. Okay, so these laws were invariably passed to protect people. However, this is one of the things that we have achieved, we have not done very well in achieving. Even if you look at the African countries that now have data protection institutions and the laws, I believe that if we were to conduct a kind of survey on progress that has been made in terms of respecting such rights, we would find that very, very, very minimal achievements have been made. And that tells you that we've made some progress. However, we have not made enough progress, for which reason most of these laws were passed. So if you're asking me, where do you think we are? We're in a good place, but we are not where we should be, and there's a lot more that needs to be done around that.
All right. Thank you very much for putting that very brilliantly. I mean, those are like really valid concerns. And of course, who else can better tell the story than you just did? All right, so Danielle, I'm going to come to you quickly. So Teki has given us a bit of background, and of course, that speaks to a couple of African countries that even have the laws in place. So now, on the other side of the divide is the countries who don't have any law or any equivalent of such law in place. I mean, Teki has mentioned that the risk when it comes to technology is decentralized, it's everywhere. And it doesn't matter whether your law is developed enough to catch up with it or to address those risks or otherwise. So, you're a Cameroonian, and Cameroon is one of the few African countries who do not have a data protection law yet. And of course, aside being strategically positioned in Central Africa, also a country that also there's also a French-speaking country. I mean, we've seen a lot of development in French-speaking part of Africa when it comes to data protection. But looking at where you're coming from, the absence of the law. I mean, what would you say are like what are the emerging risks in your country right now? It's countries like yours that do not have data protection. I mean, on that same list is you have countries like Rwanda, you have Burundi, you have Ethiopia. I mean, a long list of countries who don't have laws yet. So, what are the risks that confront people? How are they addressing those risks? I mean, are there even? Of course, there is no law, so that means maybe there is even no sufficient legal remedy in place yet. But how are you addressing those risks in country, and what are the risks that confront people who come from countries who do not have a data protection law yet?
Thank you, Ridwan. Thank you, TechHive, for having me on this panel. If I would say something after what Teki just presented, is that in Cameroon or in Central Africa, we are moving slowly, that's true, but surely. There is no specific law on data protection in Cameroon at this stage, but that is not to say that there is no law at all setting out the coverage of data privacy rules. There are several rules and several pieces of legislation in Cameroon when it comes to data protection. So they are currently found in a kind of sectoral approach. So per sector, you will have rules that will determine how to how to collect, how to store, how to use the data that is collected. So there is not a comprehensive a law on data protection, but there are so many pieces of legislation that need to be considered in a whole to have a full picture of what is actually happening. So in Cameroon, the first law that actually mentioned what we need to consider as far as data privacy is concerned is the 2005 law on establishing the Criminal Procedure Code. That is after the Constitution of the country. The 2005 law establishing the Criminal Procedure Code came up with some guidelines, but definitely the 2010 law on electronic communication and on cybersecurity and cybercrime, they came up with the platform that is worked on since 2010 till today on evolving on the framework and the coverage around data privacy rules. So there is no specific law, but there are so many laws that need to be considered to see that effectively data privacy is covered by legislation in Cameroon. And this is something really interesting to see here. So I wouldn't say that people just move around or they just use the data randomly without considering or without taking into consideration the fact that there is a regulation. So who says regulation will say sanction, right? So today, the telecom operators and electronic communication service providers know that sanction exists in Cameroon. They already know because the telecom sector is actually hugely regulated, is strongly regulated in this part of the continent. So they know what is at stake because there are the organs or the platforms, the providers that collect the highest number of data from customers. So they know what it takes to collect and to use it and to use the data wisely. So I would say on the regulatory standpoint, we are moving slowly, we are moving gradually, but surely.
Thank you very much for that. If I'll follow up on particular responsible, is there a proposed law right now addressing data protection?
Yes,
is there a proposed bill? Okay.
There is. The government is still working on it, and you have some stakeholders and some consultants doing a great job on that bill. So it has not yet been made public, but the experts are actually working on it. And I actually appreciate the way things are moving in the country because the rules are actually addressing the current issues, the critical issues on the ground. And that is something very interesting. So I really appreciate the fact that the regulator has been listening a lot. The regulator has been collecting a lot of reports from the users, and they are actually framing the law to address those issues. That is something really interesting. That will make us avoid being in a situation where we'll just be copying the laws of other countries and paste in our jurisdiction. So that is something that I really appreciate as far as the regulatory framework is concerned in Cameroon.
All right. Thank you very much. Thank you very much. All right, but I'm going to come to you now. You've been in the space way longer than when we had our first law. I mean, when we had the first data protection law in Africa. And then, I mean, it was there in the 90s too. The UK had its first Data Protection Act, if I'm correct, premised on 1998, right?
In the UK, first that was 1984.
Yeah. Okay, 84. Sorry. So I think okay. Yeah. Thank you for that correction. Yeah. So I mean, you've seen the evolution of how data protection has evolved in Europe. And of course, you've played a very critical role in development of data protection laws in a couple of African countries, a good number of them actually, providing expertise in shaping and also advising on how to develop some of these legislations and training stakeholders. So In your own 2 decades of doing this, and of course, seeing the evolution of laws in Africa, we go from laws, we go from a country like Mauritius, who is trying to do something quite progressive, to countries who are probably dealing with laws that have not been amended for a very long time and all of that. If you look at the entire value chain of this evolution, how would you sort of describe that? Then there's this phrase you always say: when you think personal data, keep it human. So what's the impact of this on some parts of Africa who are yet to adopt the laws, and the ones who have laws who are yet to even set up a data protection authority?
Well, thank you, and it is a pleasure to be here with good speakers, people who know their stuff. And you're right, I've been around a little bit, and been working in this field for quite a long time. I think the development in Africa are absolutely important, and I'm glad to see there are approximately 32 countries with laws out of 54, approximately 54 countries. And you're right, some are old and need revision, some are new but don't quite cut it. And you mentioned Mauritius, and Mauritius, of course, is the first African country to become a party to and ratify the modernized Convention 108+, because a lot of people, when they think of laws, think of the GDPR. And you mentioned the UK, our first Data Protection Act of 1984 was based on Convention 108. So it wasn't based on EU law, it was based on Convention 108. And our laws are a mix of EU law, so the GDPR, and it's a mix of Convention 108 and 108+. The thing that strikes me about Africa, and Teki touched on this, and Danielle too. So Teki talked about some of the drivers. And what are some of the drivers in Africa at the moment? You've got the huge, powerful influences, which Teki referred to as donors. So you've got donors who are driving legal digital identity and national identity schemes across Africa. And that's having a huge impact. And yet in many of those countries, perhaps they don't even have effective data protection laws, and they don't have effective regulators in place. And then you've got digital economy agendas and initiatives, both within Africa, both from the African Union. And then, of course, you've got the EU and the African Union in multiple partnerships driving the need to establish data protection and privacy laws. If I look at an agreement that was signed on the 15th of April, or agreed between the EU and the Organization of African, Caribbean and Pacific States, this was signed on the 15th of April, and all of the countries here that you're all in are party to this. And Article 9 talks about and these parties have agreed this, right? So Article 9 talks about human rights, democracy, and the rule of law, that the parties will recognize human rights are universal, et cetera, that the parties agree that that respect for human rights and democratic principles and the rule of law underpin their domestic and international policies. So what does that mean for international data protection policy? Article 15 of that agreement talks about personal data. The parties recognize their common interest in protecting every individual's right to privacy with respect to the processing of personal data, as well as the importance of maintaining strong data protection regimes and ensuring their effective enforcement. So what does that mean? These things are shaping the way that governments in Africa think. And these are agreements between the EU states and between African and Caribbean and Pacific states. And then Article 48 of that same agreement talks about the ICT and the digital economy, and that parties will promote the digital economy. And it says parties shall cooperate on developing and managing privacy and data protection policies and promote measures to facilitate data flows. Actually, that's a really important thing, because data protection laws, right from the outset, have been about facilitating the flow of data, yet across Africa, I see measures to stop that flow. I see measures to perhaps localize data, as if for some reason localizing data means the data is going to be safer. I think there are questions there, aren't there? And then it talks also, this document, and I'll share it because it's really important, I think, for people to read. Chapter 2 talks about crime and security and organized crime. So parties shall take measures to keep you all safe, to enhance individuals and communities resilient to terrorism and violent extremism. And they'll share information, fully respecting the rule of law and human rights and the right to privacy. I think across Africa, this is one of the most important drivers that I see. Every time I talk to policymakers in Africa or others from law enforcement communities, there's a big need and a big interest in sharing data across borders. But recently I was told that we can't get the data on these criminals in this country because they don't trust us. I said, well, maybe you need a data protection law. I don't know, a trustworthy data protection law. Maybe you need a data protection authority to enforce those laws. And then maybe that country would share data with you if you have the right agreements in place. And then importantly in this document, something that's quite significant. On chapter 3, it talks about population development and demography. And it talks about collecting data like census data, right? But again, under Article 7 on public administration, statistics and personal data, it says that parties to this, so all of your own countries have just signed this agreement, shall develop robust, secure, and inclusive identification systems to ensure the provision of a legal identity for every citizen, including strengthening the system of civil registration and vital statistics. That's really important because I think most of you have something in common on the panel. I'm not sure, I haven't looked at Cameroon, Danielle, but you'll have to tell me if I'm wrong. But it is, when I think of national digital identity, because this is what this agreement is about, and this is driving the need for laws in Africa too, and the need to update laws, is I look at mandatory SIM registration tied to your identity, your national identity, to your biometric identity. So I see all of these things coming together that are shaping and driving the need for data protection law and effective regulatory enforcement. If I just look at Uganda, because I think Danielle talks about fintech, if I look at Uganda in fintech space, you have all of these laws coming together and these authorities. You have the Bank of Uganda and the Bank of Uganda Act. You have the Ministry of Finance and Planning and the Constitution of Uganda. You have the Capital Markets Authority and the Capital Markets Authority Act. You have the Insurance Regulatory Authority, the Retirement Benefits Authority, the Financial Intelligence Authority, the Uganda Communications Commission, the Ministry of Information, Communications, Information Technology, the National Identification and Registration of Persons Authority and the Act, the Uganda Registration of Services Bureau and the Act, the Financial Services Development Committee. You have the Uganda Microfinance Regulatory Authority and an Act, and you have the National Information Technology Authority and an Act. And then you have mandatory SIM registration. All of these things come together just on something that sounds so simple, right? Fintech. Fintech is huge. And then when I talk of fintech, it makes me think of Nigeria and the entrepreneurs in Nigeria who are now exporting fintech to Europe. So how does Nigerian law apply to me if I use one of those fintech? These, I think, are some of the drivers for change in Africa that I see. Sorry, I probably took too long, sorry.
Yeah, that was important. Thank you very much, Pat, for setting that. And Teki, I'm going to come to you, not now, especially around the area of international transfer of data. Pat mentioned that, and it's quite instructive because I think it's something quite important. So, Francis, I'm going to come to you right now. We're beginning to, the background has been laid by the previous speakers. We're beginning to see some of these laws take roots, some of them going as far as setting up authorities. And of course, we've seen a situation where some do have laws, but yet, look at Seychelles, for example, as far back as the law is dated 2002, but you see something around 2003, but whichever of the years we choose to decide. So as far back as then, still do not have a data protection authority. And I think that could be a bit problematic. So what will be your own assessment? And I want you to do this quite quickly because you're saying bringing up number of, this year alone, we've seen the Kenyan Data Protection Authority showing up, we've seen the information regulator in South Africa putting out guidance, putting out documents, responding to emerging challenges like when WhatsApp pushed out its new privacy policy then. We'll see these kind of reactions, we see the engagement from the Kenyan Data Protection Authority. What would be your own assessment of the data protection laws on the continent?
Thank you very much, Ridwan. My assessment on how African countries are now setting up data protection authorities and can be summed up with my observation on how Kenya is handling the situation. As you mentioned earlier, that Seychelles got the act a while back, but they've taken forever to set up an authority. Yet in Kenya, the act was enacted in the year 2019, and right now the office is, you can see activity in the office. You can see they are currently holding public consultations to enact regulations to give life to the provisions of the act. I think it all goes back to goodwill from the government in power and a general understanding on what data protection is by people in government. So if people in government understand the importance of having data protection laws, its role in trade, and as Pat mentioned earlier, that the role of data protection laws in enabling cross-border data transfers and not hindering trade, then you find situations where there will be there will be data protection authorities which are being set up. There will be engagements by the authorities cross-border, which we hope we will see in this coming decade of the 2020s, and less of restriction based on sovereignty arguments. That has been an issue, as Pat mentioned, on aspects of countries wanting to withhold personal information. It was an issue in Kenya, but my observation has been there's a general understanding that data protection laws should aid trade and not hinder trade. So it's about giving consumers protections to enable that they're to enable easy flow of data from one jurisdiction to another. Like now, Kenya and Nigeria are big in the tech space, especially fintech. Kenya with M-Pesa, and Nigeria, the startup arena is big. We expect a lot of collaboration going forward, and for that to happen, there will be a lot of data transfers, where now innovators in Nigeria can be able to use information in Kenya and vice versa. The laws should not be a hindrance. Therefore, what I think authorities that are setting up should be particular on is collaboration. Collaboration with your next door neighbor, Kenya with Uganda, collaborate. Most of the times when a company is setting up in East Africa, it will set up in Kenya, Uganda, Tanzania. They will have like one regional office. Data protection authorities should factor in such situations so that there'll be easy flow, but also it brings in aspects of accountability for the users or customers of these entities. So it will be a win-win. Governments will benefit from trade. People will, consumer protection rights will be protected. Yeah.
Yeah, thank you, Francis. I mean, you've also been able to mention things around how trade is actually connected to cross-border data transfer. We're going to get to that pretty much later, discussing the African Continental Free Trade Agreements. But before we get into that, Teki, I said I was going to come to you around cross-border data transfer. So, I mean, having a scan of the different data protection laws across the continent and the framework they created or that they've created for international transfer of data. We've seen a variegated framework where we have countries dancing around adequacy to the ones providing derogations like consent, contract, vital interest, and stuff like that. Then we have the ones who say, before you can actually even move it outside the country, you need to get the authorization from the Data Protection Authority first. So interestingly, if you look at one of the draft regulations that was released by the Kenyan Data Protection Authority lately, I think one of the grounds for international transfer of data is any country that has ratified the African Union Convention on Cybersecurity and Protection of Personal Data, which Kenya itself is not a signatory to. The same development in Nigeria, where part of the white list of countries that Nigeria considers to have adequate protection laws includes countries who are signatory, not even ratified, who are signatory to the African Union Convention. And some of these countries, a country like Comoros, for example, who is a signatory, a country like Rwanda, who is a signatory, they do not have a data protection authority. So how do you consider countries like that adequate when the rights can actually not be enforced? So these are some of the issues we're seeing. We're going to get to the problems pretty much later. It's a long list, but in your own experience, I mean, we have a country like Ghana too, where the framework for transferring data outside Ghana is actually not clear. So, I mean, our businesses, how are they meant to do cross-border businesses? And not just because intra-African business, but also businesses that goes outside of Africa. So what are the things? Should we be having a rethinking around our international JANTRA framework? Francis has mentioned collaboration. I know there is a body that represents all data protection authorities in Africa where they sort of have conversation and stuff like that. So what should we be thinking? Should we be having a rethinking? What will be your assessment of the international transfer of data framework currently as we have it?
Okay, so data transfer, I think we should start from the right premise. Data transfer is inevitable. Within Africa, it is even more necessary within Africa because if we look at our technology space, which most of our countries are hoping would facilitate development, economic development, innovation has significantly been driven in most of our countries as a result of technologies that have made it easily accessible for our young tech industries to launch on a number of things, i.e. technologies such as cloud and other platforms. A lot of these platforms, as you know, are not necessarily present within our countries. And so those cloud systems may be anywhere in the world, you know, and usually not present in our country. So we need to have that basis that, you know, transfer maybe it's inevitable. Now, the next issue is that protection is equally important. It is. We have to make sure that personal data is adequately protected. We cannot also say that because data is being transferred elsewhere, we are washing our hands off the protection of that data. And that is why you've seen, as you rightly put out, a lot of the legislations have been trying or looking at interventions that may help minimize the risk that these things pose, that transfers pose to the citizens within their respective countries. I do not think that, looking at the way Africa is, looking at the various backgrounds and histories that our respective countries have, I do not think that we're going to get to a place where we have uniform laws, right? So even within Africa, I do not think we're going to have uniform laws that will enable as easily say that, okay, Cameroon has the same law as Ghana, you know, because even when we have that, there may be variations of how implementation is even being done, the strength of the regulator, the credibility and integrity of the regulator, and a whole host of things. So what should we be doing? And I would say that this is not a very simple question to answer, because it's an ongoing thing. And even where you find the right fit as a regulator, you will continue to have challenges in subsequent times because of how these things are done. I do not subscribe to legislations that necessarily say, okay, adequacy may be good, but if you know how difficult, even between the African countries that have requested for adequacy with Europe to now, if you know how difficult it is, you know, to get some level of adequacy, you will realize that when it comes to doing business, that is almost near impossible. From my experience and based on communications that I have had, usually we see Europe giving, or European countries giving adequacy to countries that they have a significant business interest with, right? Of course, they look at frameworks that they have, and they look at some kind of standards and structures that could enable free flow of information between these two countries. So we have to look at a number of things. I don't think that our laws are necessarily going to help us, as you rightly pointed out. If you look at a place like Ghana, and I believe this was one of the reasons why our legislators did not put a concrete stamp on it, and they placed what they did, which maybe industry would not like because it doesn't give them a clear-cut situation on what it means, is they placed the obligation on the person that is transferring the data or sharing data to another jurisdiction to ensure that they have the same level of protection that you have. What that does for a regulator is that it takes away you know, the constant policing stress that you normally do not have even the resources to manage, and then leaves, you know, that obligation on the data controller, which gives the regulator an opportunity to visit these issues. You may say when it's too late, but usually when there are issues, which is when the regulator will even have the time and the resources to dig into the issues and advise appropriately. But that doesn't stop the regulator from giving guidelines, right, on what would be the same conditions, what would be appropriate. But I think that from the reasonable man's perspective, we all know that if I'm sending data or I'm transferring data and I want to guarantee the same level as my country, you know what kind of standards you're looking for. And fortunately, technology service providers and cloud service providers are also somehow providing more information on how to ensure that even though you're sharing that information, you're able to do that. Within Africa, we have another challenge, you know, and I think that it cannot be singled down to a simple thing as ratify or sign the Malabo Convention. It may be a good thing, it may be a good pointer, but as you rightly noted, it does not necessarily indicate, you know, the ability of whoever you're sharing the data with to ensure adequate protection. So it tells you that we need to do a lot more. And that is why maybe our African countries are not even trusting each other. And today we're talking about an Africa free trade, for which digital economy is a significant part of this work. How are we going to ensure that? I think that the issues around data transfer should be looked at from the perspective of a harmonized framework, not a uniform framework. And so when I talk about harmonization, I am looking at, the ability for either data protection institutions to collaborate, whether at the regional level, continental level, around they should agree on certain key parameters and standards that will make it easier for information to flow, let's say from Ghana to Nigeria, Nigeria to wherever else within Africa. We should be able to agree on these. Now, when we do that, what this does also for industry is that it provides some clarity for industry, right, on certain minimal standards that can be set across board, which is, and look, we do these things even without data protection laws. When companies realize that to get businesses, they need to have adequate protection, they had self-regulatory principles and all of that. So it's very possible for, let's say, our regulators to come up and say that, okay, within West Africa, these are the standards, or within Africa, these are the standards that will allow for transfers of data, and it will invariably make it easier. If you're a country that have data protection laws, these are the standards you should maintain. If you do not have data protection laws, these are, and this will end up accommodating a whole lot of people, because we cannot run away from transfers, especially in the times that we're living in. So we have to look around systems and structures, and that is not to say that we won't make mistakes. A lot of the learning is going to come from the mistakes. So we shouldn't inhibit, but we should create or put in place systems that facilitate the movement of data, while at the same time ensuring adequate protection and continuing to monitor some of these standards to ensure that the right thing is done.
All right. Thank you very much. I mean, that's getting into it exhaustively. I was going to go into AFCTA, but you brilliantly, I think, touched on that. And I think that recommendation you made around harmonization and creating framework for those who have and those who don't have. I think maybe in between it, to those who don't have an authority to enforce the laws yet, we might as well be thinking about them as well. But I think that's a very brilliant and very genius one. So Frank, I'm going to come to you right now. And a question is going to be around, I mean, you talked about mandatory SIM registration. I personally have qualms with it myself too. And if you look across the continent, more than 50 African countries by legislation makes it mandatory to register SIM, to mandatory SIM registration. And often than not, these are things that are actually tied to national security issues. In Nigeria, most recently, the national identification number, which is pretty much like a unique identifier for every citizen in the country, is being linked to your registered phone number. And the argument the government is making out is that it sort of strengthens security. I mean, there are so many technical arguments why that itself, it's not what it might truly represent. But I know you very well, having worked with, you've worked the mobile industry, in the telecom industry. Can you give maybe just some sort of a brief appraisal of all of these things, all these kind of policies that will sort of tie back to national security? I mean, how are these things, how are they actually advancing human rights? So yeah, thank you.
Was that to Frank or was that to me?
Yeah, that's what you part. Sorry.
Me. Okay, so just before I touch on that, I mean, there was that discussion of adequacy, and it would be good to hear from Danielle and Frank also, in that, because I think the concept of adequacy is inadequate, and we should be thinking about what are the appropriate safeguards in the context of data flowing across borders and the risks to rights and freedoms and to that presents, because we talk about transfers. If it's something I do, I get this data here and I send it here. From the moment that we have the internet and the web and the wonderful things that it provides, data was flowing across borders between multiple parties simultaneously. And that's the reality. All of you on the panel, and I assume those on the call, also, the thing you all have in common is probably a mobile phone, right? And I assume the other thing you have in common is that you like some of these apps from some of the big US entities to help you call each other and message each other and share information, right? So every single day, your data is flowing across borders. So that brings us back to the issue of cooperation. The African Union has the Policy and Regulation Initiative for Digital Africa, PRIDA, that provides an opportunity for African countries to come together to harmonize on data protection and privacy, but also perhaps the need for enforcement. But so they're some of the things just coming from Teki's conversation. But in terms of mandatory SIM card registration, I mean, as far as I'm concerned, it's the biggest lie on the planet. I mean, to suggest that mandatory SIM card registration is necessary for national security or for law enforcement, I don't believe that it is. In fact, I was one of 5 authors of a report for a former UK Prime Minister, where we managed to convince the government that, in fact, mandatory SIM registration was unnecessary for those purposes. And I think, why is it that, think of the impact of mandatory SIM registration on your right to freedom of expression, your right to freedom of movement, your right to freedom of association. So mandatory SIM registration has your national identity number. It could have your biometric data. It's linked to who you call, who calls you, where you were when you made the call, where you were when you finished the call. It can be used to tie individuals. For example, people have a right to democratic protest. So, you know, all of this data, particularly mobile SIM registration data and mobile traffic data, can be used to understand, for example, where people are moving from, where they're moving to, in order to listen to, say, a democratic opposition party. And it may be that that data can be used to intercept and to corral them and to prevent them listening to this person, which is an infringement of the right to freedom of expression, right? Which is not just a right to say something, it's also a right to hear something, to receive information. So for me, I worry that mandatory SIM registration just creates a surveillance infrastructure. And I'm not convinced that it meets fundamental tests of human rights. No, not at all. And I'm conscious that Danielle and Frank, I'm conscious of the time and also of them to also provide their views. And I'm conscious that Bilal Toure has put a good question in, which maybe we can get to later. But for me, mandatory SIM registration is the biggest lie on the planet.
All right, thank you very much, Frank. Then I'm going to come to you right now. We'll continue to see violations of data protection rights on the continent, and that happens it happens through so many means. So from government violation to private violation to even individuals who don't see how their own exercise of rights could actually impact on your own exercise of rights. So, and a very simple example is whenever it is that you tag people or you share your address, for example, your address, for example, doesn't belong to you alone. If you share your address, you also share address that has to do with other people living in a particular building, for example. So that's how your own exercising your own rights could also impact on some other persons. So we'll continue to see violations in so many ways. Facial recognitions are being deployed by public authorities, and of course, it's been used by private organizations too. We did a recent research in Nigeria currently, and we saw quite a number of them that's actually using facial recognition and providing services to some of the commercial banks that we even have. So we're seeing all of these things being used, facial recognition, different uses of artificial intelligence for different reasons. And all of these things, when we measure that against the number of the issues being addressed, and when I say this, I mean maybe when in situations where there is a country and the data protection authority is is able to even conduct an investigation and maybe issue sanction and stuff like that. It weighs lightly when we compare the two. So with the continuous violation or the violations that we're continuing to see, what are going to be, so first thing is, what's your assessment of violations? But of course, what would be your own suggestion as to how to manage this, especially for countries who do not have laws? Because the ones who have laws can't even manage the violations. So what do we even do in situations where, I mean, the laws are actually not addressing issues specifically? Yeah, Danielle.
Thank you, Ridwan. I would like to come back to what Pat said earlier. He was talking about the necessity to consider the driver, right? The driver to improve on the regulatory landscape. And fintech in our jurisdiction has been a huge driver. That is from the ordinary mobile money payment platforms that we had to interoperability that is already effective in Central Africa or in the Central African Economic Zone since last year. So the regulator has been able to see what are those current violations, because the regulator has made it possible to report, that is on the spot, to report the violation. So people are getting more and more aware of the various options that they have when they find themselves in a position where they are a victim of a violation of their privacy rights, especially today because of the use of, in fact, the mobile money transactions and everything that has to do with digitalized payment and all that. So today, in this part of the continent, in fact, I guess it's everywhere in the world, but now that there is this kind of digitalization of access to money, people are getting more and more aware of, okay, I had 500,000 later, I had 500,000 in my account like 5 minutes ago, but I'm getting a notification as if somebody is trying to withdraw me from this account and I'm not the person ordered. What are you going to do? Like immediately, you are kind of, okay, very attentive to what is happening. And the next thing you will do is that this is my money. I need to protect it, and my money needs to be safe. You will definitely report it to the operator first and to the regulator second. This is exactly what we are living in Cameroon and in Central Africa now, in fact, since last year, that today you don't even need to use your card to make an ATM withdrawal. So everything about how we use our money today in Central Africa has made it, in fact, it has created a huge awareness as to those violations when it comes to cybersecurity and cybercrime. And the Information and Communication Technology Agency, the National Technology Agency in Cameroon, is really, really responsive. So whenever there is a report on any violation, you will receive a response from the authority in the next 48 hours. And what is that response going to cover? It's going to cover from the name of the infringer to the IP address. So now it's left to you to use the information that you got from the regulator to initiate judicial proceedings against the infringer. So people are getting more and more aware of their rights, of the way that data is used, and the way their property, because we are talking data is a property right now, and we are now talking about money, and this is creating a kind of, alert in a second. Anytime you feel that something wrong is happening to my mobile money account, the next thing you will do is to report it. So fintech and the increased use of fintech platforms has been a huge drive in terms of awareness, in terms of regulation, and also in terms of implementation of the law that has already been enacted. So today we find ourselves in a position where the regulator is being inspired by the real life situation that the consumers are living in our jurisdiction. And this is something we really need to appreciate. And the responsiveness around the reports that the regulator will receive within a very, very short period of time, something that we also need to to comment and appreciate. So this is what is happening in Central Africa at this moment, and this is something we really need to keep watching, because the regulator is getting inspired by what is happening on the ground. Situations are evolving too fast. The infringer is coming more and more like the awareness, so to speak, of the consumer, of the user, that is also coming up with kind of sophisticated means to infringe or violate the rights of consumers. And to talk about the regulation, recently in July 2020, the Central African regulator, the CEMAC regulator, has come up with a regulation on consumer protection, the protection of consumers of bank products and services. And that regulation covers the activities not only of banks today, it also covers the activities of mobile money providers. So mobile money providers or payment services provider, so to speak, they are being considered today as banks from the regulatory standpoint when it comes to protection of data.
All right.
When it comes to protection of data. So yes, so fintech has been a huge driver, and we will get to see in 2 years' time or in 3 years' time how the situation is going to evolve, because the infringer is not sleeping, definitely. He will be coming up with more sophisticated means to violate the rights of consumers. And the regulator is now using those case scenarios to improve on the regulation that is being drafted.
All right. Thank you very much, Danielle, for providing that very key background. So another question I'm going to ask you, and quickly I want you to respond to this, is that the activities or actions or things you're seeing from the regulator, how do they do that if the violator, for example, is a public authority? And I want you to answer that quickly. If it's a public authority, how do they respond? How have they been responding?
Who are they going to respond to? They respond to the user, that victim. I'm the victim. I'm writing to you. You are the regulator. You need to answer. And you have to do it because you said you will do it in 48 hours. You will do it. And this is what has been happening. Like live scenario, you contact, in fact, you report an incident. You get your phone within 48 hours, and it's not left to you to use the information on the report that you receive from the regulator to either file an action against the infringer or not. That at that time, it is left to you to choose.
Okay, thank you very much. I mean, that's interesting. That's an interesting model. I mean, it's probably easier when they're trying to regulate things like financial institutions and telcos, because these are like really regulated industries. I wonder if the same is the fate of sectors like healthcare. But I'll come back to you later. Francis, I'm going to come to you right now. Before I do that, I was meant to drop this interesting fact after Teki wrapped up our response on international transfer of data. So interestingly, I think Nigeria is the only country that has whitelisted other African countries. Morocco did issue an adequacy decision in 2015, but it didn't include any African country. So, but interestingly, Russia and Serbia has granted a number of African countries adequacy decision. So that's quite interesting. That's an interesting one. And I'm trying to see that from a commercial point of view. What interest do we have in terms of Russian African trade or Serbian Afro trade, between maybe specifically those African countries? So that's an interesting point. And we'll see how we interact moving forward in the continent. So Francis, I'm going to come to you right now. And we'll continue to see deployment of emerging technologies in different African countries, and sometimes away from private sector, who are actually the main driver of the use of some of these technologies. The government is actually using the same too. And sometimes they are already automating even some decision-making process, which, of course, all these technologies are questionable themselves. So in your own assessment of what we've seen, there was a report, I don't want to speak to surveillance specifically, but there was a report about tools from countries like China increasingly being used in some African countries. So And beyond that, so again, like I said, in Nigeria, for example, we're seeing increasing use of artificial intelligence in critical sectors. We're seeing deployment of facial recognition technology in even private use of some technology and stuff like that. I mean, what's your own assessment of deployment of this technology vis-a-vis the principle of fairness? And of course, how do you think these entities deploying this, how are they fair? Are they actually trying to comply with the law? Are they trying to ensure there are safeguards that people, again, when we say, like the part you always say, when you say data, think of the people behind it. So are we sure, what's your own assessment of deployment of this technology and as it relates to the human rights or the people who are either users or who are actually victims of some of the decisions that is made by the use of these technologies?
Thank you very much for your question, Ridwan. On what I think about the deployment of these technologies and the impact on data protection, I think it depends on the context. In most situations, it's like the technologies are being deployed because there's no accountability systems. So you can get away with so much in terms of trying to test and see how far you can go. And I think this has been a good case example, which I've observed over the past few years, has been in the use of, let me call it, automated decision-making systems in mobile lending, especially now, in Kenya. There are companies which have come and set up in Kenya and start giving out loans to people. And their automated decision-making, I think, in 2 points. At the point of credit scoring, although now that credit scoring, and then, but that's, I don't think credit scoring is actually really an issue. The main issue, according to me, has been at the point of listing of defaulters to credit bureaus, where now they give you a bad credit score due to your failure to pay back your loan. So you see deployment of these technologies or these systems in, like, let's say in Kenya, way before Kenya even had a data protection law. So, and because of the environment in Kenya, lack of regulation in the sector because of that approach that the government had to enable the growth of fintech, so many predatory apps came and set up, gave people loans, and it became an issue. As we speak right now, there's a bill in the Kenyan parliament seeking to address this particular issue of predatory mobile lending apps. The Center for Intellectual Property and CPIT, Strathmore, have even recently released a report on these apps as well. But you see that for the longest time, entities came and tested these technologies here without any regard for human rights, ethics, and the results have not been so good. On the business end, some entities have been ethical and have reached out to regulators and have even called out their peers. However, one bad apple usually spoils the rest. And one bad apple can also cause a huge difference in the entire industry. Like right now, when I think about all those cases of suicides in families and embarrassment, I wouldn't be so gracious to. I'll be as a regulator, I will definitely go hard on players in these sectors. Now, that is in the financial sector, but you see now for financial sector, it impacts a lot of Africans. And even if you look, listening to this conversation, you'll notice that fintech is a big issue across the continent, Central Africa, West Africa, and these technologies are being applied in those situations. So I feel like regulators need to be watchful of this and engage, so that as much as they're also regulating the industry, they do not hinder innovation.
Right.
So you find yourself in that scale where you want to enable an industry, but you also don't want to, you also have to protect people.
Yeah. Thank you for that. I know, Frank, Pat, I know you're interested in this particular subject. And interestingly, 2-3 months ago, I can't remember specifically, we also published a report on digital lenders in Nigeria, where we looked at about 23 of them. We analyzed their mobile apps, the websites, the services they provide. And what we found out was actually quite discerning. Like you also mentioned about automated processing, which is actually a requirement that even needs to be specified. And of the ones that we looked at, only just about 3 of them actually mentioned the fact that they actually do automated processing in their privacy notice, for example. When the mobile apps found trackers which you are unable to actually even link to the service they are providing. We found excessive permissions, found so many violations of consumer protection laws and stuff like that. Then even beyond that was a situation where we found out of 23 apps we looked at, 4 of them, if you click on the privacy notice, it takes you to the same page, which means maybe they are being run by the same entity, but I don't know. I don't want to. I mean, no theories, but it's quite interesting what's happening in that space. And Pat, I want you to quickly respond. I'm being watchful of time, and I need to ask Teki a very important question. So I know you want to react to the mobile. I'll ask you the hard questions. So I know you want to respond to the mobile money part, and I'll let you do that quickly. Thank you.
So just on those points, Danielle and Frank raise important points. And to Danielle's discussion, mobile provides benefits to hundreds of millions of people, and Africa is an innovator on mobile money. And I wish we had some of the services here. However, the pandemic is driving us towards a more cashless society. And the thing that concerns me in mobile money is transactional privacy. When all of your payments are made via mobile, who has that data? How is that data being analyzed? That transactional data reveals an awful lot about us. And then to Frank's point, I've looked at some of those mobile money apps in Kenya and I'm shocked, truly shocked. And it's clear that your mobile number is becoming or is being used for reputation scoring. Now, one of those apps, and Frank didn't name it and I won't name it either, but I'm quite happy to privately, goes through your contacts. So you've got the privacy of others. How many times do you all say, yeah, sure, access my contacts. Yeah, upload my contacts. Yeah, suck my contacts into your system. So these apps, one of these apps particularly would trawl through people's contacts to call them for debt tracing purposes. And Frank raised the point, that people may be driven to suicide. Now, when you think that some of these less scrupulous organizations will trawl through your contacts in order to call them, to chase you, to discuss with them and to find out where you are because you owe money to this lender, then what does that do in relation to the person's reputation, in relation to the person's dignity? We begin to see some of the harms, very material harms that can occur to people through clear lack of policy, maybe a lack of effective protection in law, maybe a lack of effective regulation. And one of those apps I know for certain uses is based in a particular EU country. So those Kenyans will be protected by EU law. And this is where you have the interesting question, and Teki is an ex-regulator, so you have the interesting question of the Kenyan authority and what will be the legal basis to liaise with the EU regulator, and what are the legal obligations upon that EU regulator to deal with a regulator in Kenya I mean, quite clearly in the Convention 108 plus, any party that ratifies that, there's this legal obligation for those regulators to cooperate with one another. And actually, 108 plus gives data subjects in whichever country that is a party to 108 to go directly to the regulator in that country and say, hi, I've got an issue, can you help me please? So there's some of my thoughts on mobile. Sorry.
Thank you very much for that. So, Teki, I'm going to come to you now. So 2 things. Independence of the regulators is actually one of the problems that have been identified. Yeah, you're smiling. Yeah, independence. Independence is one of the biggest problems that have been identified across. And I mean, the question of independence is multifaceted. It's from, if you look at the Convention 108 plus, for example, if you look at its definition or sort of its conditions for having an independent authority, things like members of the executive cannot be part of the data protection authority. And you see so many data protection authorities across the continent, either they are domiciled in the presidency's office or domiciled under a ministry, or a ministry is having a supervening, or the prime minister is having a supervening role, or what, all sorts. Things that at the end of the day don't really give them that power to act as independent as they should be. And if that's countless examples I really don't want to get into because of time. But when we speak to independence, I mean, what kind of conversation should we be having when it comes to independence of data protection authorities across the continent? How is this also affecting their own effectiveness? Are they just sit idle, get a budget every year, publish a report if they want to, or if they don't want to, of the annual, of their performance review for a particular year? I mean, I want you to let the audience understand how strong or how core is independence to the success of any data protection authority. Thank you.
I don't know why you're asking me the hard questions. But independence is a very significant, I would say is the core of any data protection authority. Without independence, you might as well not set up a data protection authority. And there are a number of reasons why I'm saying that. If you look at the role they play, right, the policing role they play, even for you as a government, a very independent data protection authority helps you as a government build integrity and trust into your own data collection and management processes. So if you have a data protection authority in place that does not feel confident enough to come to you, or is not given enough powers by way of resources to be able to take decisions, that quote unquote may negatively affect you as a government, then we have a problem there. And what tends to happen is that, which we don't realize, and I had this experience when I was setting Ghana's Data Protection Commission up. I remember someone from the private sector told me, is this not just one of those laws, are you able to even enforce it? And one of the first challenges we had with an enforcement action with SUP, which was not a very big thing, but it had a very positive impact on the institution. It was what we call the naming and shaming, where we had to identify certain institutions in a critical sector which were not complying, and then publish their names in the dailies and all of that, let the media follow up on it. I remember that when we did a survey and then got the list, because we were not publishing everybody at once. One of the biggest decisions we had to make at the board level was, which institutions, and you would know there was a very powerful government institution in number one, as one of those. And everybody was, there's that natural feel, this is another government institution, they are well connected and all of that. But the point is that if you fail to publish that, you lose credibility with your entire stakeholder base, including private sector, because if you are unable to enforce the laws against the very institutions, call them government agencies, that have set you up where you have a mandate to deal with, then you're going to have a challenge. In other jurisdictions, if you look at Canada and other places, they deal with government institutions differently. If you look at most of our countries, however, our data protection laws or regulators are supposed to also govern or regulate the public sector. And that is where that challenge comes in. The second challenge to independence has been resources, right? So you want to enforce the law against the Ministry of Finance, but you're going to submit your budget to the Ministry of Finance. How else do you? And so we need to look at legislative processes that guarantee, you know, the financial stability of these institutions. In Ghana, for example, we have institutions that, especially the constitutional institutions, that are guaranteed a certain, you know, nobody can really intervene or cut back on their budgets and other things. And that really strengthens them. But even then, it's not foolproof. So you need to look at that. Another strategy also to making sure that the institution or the appointment of the leaders of the institution is not politically exposed, is to explore approaches around maybe parliamentary approval, public advertisements, parliamentary approvals, which means that you're going to get at least both sides of, or all sides of political divides coming together to approve who becomes the head. Then, you know, it insulates the institution or the head. But where you have executive systems of government where individuals are appointed, it makes it extremely difficult to sometimes be able to stand up and stand in front of the very person that appointed you and say that you're doing the wrong thing. It can be done, but it's not an easy thing, and it's not everybody that is able to do that. So independence is important, and I think that we have to continue to raise more awareness with our governments why this is important. The data protection, the industry that data protection oversees is not a political space. It goes beyond politics, and it affects almost every facet of society. So if we do not empower these institutions to even, you know, advise, so to speak, even advise government agencies, if we do not empower these institutions such that they are respected when they give requirements or guidelines, we are going to even weaken the very basis for which we set up the data protection authorities in the first place. So we need to advocate the reasons for it. It should never be a political entity, you know, and politically exposed people should not be allowed into these institutions. We should make it what it is. It's a highly technical place where people who are knowledgeable in the area with skill sets should be allowed to go there to do their job. And trust me, if you do that, you would see the strides that you'll be able to make in an industry within, you know, a very short time. So that's just what I will say about that.
I'll say a tough response to a tough question. And thank you very much for doing that. So Danielle and Francis, I'm going to come to you. But before I do that, I know we're also we're almost running out of time. So Frank, Pat, I'm coming to you quickly now. And my next question to you is that, sorry, hang on, please. Okay, so there has been so many conversations around the intersection of data protection with competition, with consumer protection, and I mean, different frameworks. quite a number of African countries already have consumer protection laws, and some of them somehow either infuse a competition law or maybe have the competition law in a different body of law. Do you see this working as also a stretch of maybe the data protection laws? Could consumer protection framework, for example, also give some sort of succor to some violations that straddles between those two concepts? Or if there's an ikigai, if I'll describe it, it sits in between those three concepts. I mean, how much of impact do you think looking for relief under consumer protection or maybe a competition or anti-competition law, how much of relief do you think we can get under that?
Well, it's a good question. We see in Europe competition authorities both examining the power of companies and platforms in relation to their access and use of data, but also we see them fining organizations for data protection abuses because they seem to have powers that allow them to do it much more quickly than data protection authorities, and they're perhaps not bound by the same rules to cooperate with one another on some of these things. Interestingly, in one country in Africa last year while I was working on policy, the competition authorities folks were in the room for the week that we were there, and they were definitely interested in this and definitely felt that data protection had a role and that they had a vital role to play. And I agreed, particularly in that country, which isn't huge and doesn't have a lot of cash. I think you have to be really effective in how you use regulation and regulatory instruments and how you use different regulatory bodies to give good effect to data protection and privacy protections, if you like. So I do think that competition and markets authorities have a vital role to play, and I do think, and I see we see data protection authorities and competition authorities and consumer protection organisations coming together. I mean, look in Norway, you have Forbrukerrådet, which is the Norwegian Consumer Council, are really effective. They're doing great work in raising issues and challenging companies through due process.
Thank you for that. So the follow-up question I'm going to ask you is on data localization. So we're seeing an increasing number of localization laws. And Francis, I want you to chime in on that as well. We're seeing an increasing number of localization laws across different African countries. I think more recently we saw, what we've seen recently is the South African drafts cloud policy that is saying data belongs to the South African government. And I mean, data like that, I mean, so there have been different arguments for localization in a particular African country where I'm also trying to review what they're doing currently. I've seen where they didn't do express prohibition of forced localization, but rather picked on certain sectors, categories of data, like these particular categories of data are not going to move outside the country. Similarly, in Nigeria, the Data Protection Bill 2019 that the president refused to sign to. One of the criticism the bill got was the mandatory localization of data, and to that extent, there was a sanction of about 8 billion naira, which is almost equal to 20 million euros as a then, and also an imprisonment term of about 8 to 10 years. So, which is completely, for lack of word, doesn't really make sense. So, I mean, like I said again, there are so many arguments for localization. So, I mean, what's your take? Is it good? Is it bad? Should it be measured, or should we just have completely liberal terms as to mobility of data? That's for you, Pat.
I think I'd rather hear from Frank and Danielle, to be honest, because I always have views, but I'm not a fan, but let them.
All right. All right. So over to you. Who wants to go first? Danielle or Francis?
Yeah, Ridwan, what I would say about data localization, I think at this stage, it will be very, very difficult to say that data has not been moving from one country to the other freely. That is exactly the situation we are living at this moment. So the best thing we can do, because it will still be difficult to compel a service provider to localize the data in a particular jurisdiction without that particular provider using that data in another jurisdiction. So I think it will be very, very difficult to assess and very difficult to control, because the rule can be here, but how to implement it can be another piece of cake. So I think what has happened till now will be difficult to stop. But regulation in terms of standards, it is actually very interesting, because we will find ourselves in a position where we will make those standards known and will create awareness around the standards for the users and the providers to be at the same level of information. The moment they request the consent of the user to collect its data, the moment the user provides its data, the moment the provider keeps and uses the data, the information should flow. And in terms of regulation, all the actors should be at the same level of information. That one will be important, so that when the user provides its data, it should be aware on that throughout the process of obtaining its consent. It should be aware of what is going to happen next the moment he signs that consent, or the moment he gives that consent. Where is my data going to find itself today or tomorrow? If you know, then fine. To me, that knowledge upon giving out the consent is vital, so that you won't say you didn't have the information. As the consumer, you had the information. As the person in charge of collecting the data, you had the information. When everybody is aware, it will be easy, if I will be very difficult to say that there has been an infringement, or that, okay, they have said that this letter should be localized in Cameroon. Now I find the data, in fact, one of these people in charge of direct marketing, let's say people sending marketing messages or unsolicited messages through your phone, you won't know how your data got to them, that they are now contacting you saying that we are doing marketing for this particular product, or this is something that might be of interest to you on the marketing perspectives, from the marketing perspectives. You won't say that you didn't know that your data will leave this Cameroon and find itself in the US. You won't say that, because you were aware. The moment you gave your consent, you had that information that your data could be used this way or the other way. Okay. Because having it saved in one particular jurisdiction, it is not a guarantee that it is going to stay there without being used in another jurisdiction. So nothing will make you anticipate on that particular use. But if you gave your consent knowing that the information may be transferred for X or Y reason for which you actually gave your consent, I think it's enough. Information should be the key. And if everybody is aware, then it will be like there will be less hypocrisy in, localizing data in one jurisdiction or the other.
Okay, thank you very much. I think it's also important to point out that for so many African laws, especially for the ones we've been able to map, consent is usually one of the, let me say, derogations to transfer data. There are a couple of other lawful bases or justifications to also move data outside a specific country. So I know, Teki, you want to respond to these as well? Well, I'll let Francis go first before I come to you.
On data localization, I have a short story I want to share with you guys. In the year 2017, during the presidential election petition, the Electoral Commission was asked to produce some information, and their lawyer was like, the information is in the server and the servers are in France. So there were orders like, open the server and people physically wanted to go to open the server. So this aspect of cross-border data transfer and data localization becomes an issue in Kenya because of that situation in 2017, where people make reference to the opening of the server not being in Kenya. That server, I'm referring to the voter register not being in Kenya, and when it's needed, it's not available. So the general sentiment, even when the Data Protection Act was being legislated in Parliament, I remember listening to some member of Parliament say that we cannot, yes, the law requires for consent for transfer of data, but we cannot ask for consent from each and every voter for their data to be stored in France, or to be so that it may probably be moved to another country. So that generally gives you the general perspective of or understanding of people on the issue of data localization and cross-border data transfer. However, I feel like market forces will prevail and trends will prevail. Yes, there are concerns on data localization and everything else, but whatever is best for the country in terms of the economy and national security, of which those scenarios are different, it will be best if it's dealt on case by case basis. And yeah, so I don't think it's going to be an issue where people will cling so much on having information. If it doesn't make business sense, then eventually they'll have to just let go.
I was wondering if eventually they opened the cloud for people that wanted to enter the server that time. All right, thank you.
People still want to go there physically.
They want to go to the cloud.
Yeah, so I just wanted to say that when we are talking about data localization issues, one of the first things that anybody that wants to look at data localization should do is to ask themselves, and whether they are governments, policymakers, or whoever, what is the mischief we are trying to address or cure? And a lot of, I'm saying this because that has been the challenges that I have had to a lot of the data localization interventions that we have seen by law. A lot of them usually come in from the perspective of the fact that if data is transferred outside my country, there's a security element to it, which says that if data is transferred outside my country and somebody does wrong, the security forces will not have access to the data. So there's that fear element around it, and that is what drives that. And you know, for me, that broad or general data localization law is a problem, because it's going to be something that is very challenging to enforce. It may inhibit innovation within your industry, because the growing technological industry it's an industry space that usually our young developers and all of that will not be able to afford the economic gains that come from large platforms which are available to them elsewhere. So that is one of the concerns. And if the concerns is around security, which is legitimate, then we should look at, we should start looking at what category of data am I dealing with, right? Because it's fairly right, if you go out elsewhere, it's done anywhere in the world, to classify certain kinds of data. Some of our laws recognize what critical data is and provides for further protections around what is seen as critical data. And so with that, you can then decide that when it comes to critical data, we would request that, you know, the data is localized for whatever reasons there is. But I am usually afraid when we decide to take a blanket approach to addressing some of these concerns that we have, which is why we call for data localization laws.
Thank you, Teki. Pat, I'm going to come to you now to provide your response. There's so much that we need to talk about, like I said. So I wanted to do that. And of course, also, I mean, we've talked about the lessons, and also you prefer some of the things that you consider could be the best way forward. There are a couple of questions there that I also want us to take, but I think you can just provide your response on the localization. We'll get into the questions and we'll take recommendations much later.
Yeah, Teki raised excellent points there, as did all the speakers, but you have to begin with what's the policy objective? What, as Teki said, what's the mischief, the harm that data localization is intended to address? Some efforts I see, and Teki alluded to that, was that, well, it's economic matters. We feel if we have the data here, we can spur innovation, we'll have entrepreneurs flourishing under these digital economy agendas, right? So that's one of them. Others are, well, you know, these guys have spies in their countries. They might just get access to the data as if spies in their own countries are not as bad as spies in another country. So what are the harms that are meant to address? I haven't really seen a clear articulation of those in some of the localization initiatives that I've seen. And then localization, I've seen proposals for the localization of non-personal data because it's of national security importance, and that, to take France's point, data on economic data or protecting the economic interests of a country can also be seen to be in the national interests of a country. So yeah, I just think it needs a lot more work, and I think we should come back to the premise of a key objective of data protection law right from the outset is it's to facilitate the free flow of data. And as that data flows, to ensure appropriate safeguards are in place to protect fundamental rights and freedoms of individuals. And you don't do that by knee-jerk policy at all. And technology can solve some of these problems, for example. I only have to look at the Signal app, you know, how that's dealing with it compared to, say, WhatsApp. I mean, come on, there's two entirely different tools here that provide different levels of protection for privacy. And, you know, that don't need those policy, well, maybe one of them needs a policy instrument, but not the other one.
Thank you very much, Pat. One more issue that I'm going to put out is, Francis, and I want you to take this because I think Kenya is the most recent example of such country. So funding has always been one of the problems that have been identified as one of the challenges plaguing the authorities in Africa. And now we're seeing authorities trying to come up with creative ways to source for funding beyond waiting for government statutory grants, or the government decides to deprive them of grants, then it means they can't employ, they can't get the best hands to do the job, they can't put out content that are relevant to people, and they can't do their job effectively, in essence. So one of the things you're seeing is data protection authorities charging for things like registration, which I think is a model that maybe, I would say started in Ghana, but it's a popular model in Ghana where controllers are meant to register. And I think in Kenya, more recently with the draft guidelines that we saw published, things like data protection impact assessments, there is a fee attached to doing that. And I'm thinking, if you're doing impact assessment, for example, to sort of look at the risk and danger to rights and freedoms of people, if you start charging people for it, they will just probably not do it and not let you know, and just push out the products like that. So, I mean, I'm just looking at the scenario there. Is that what we're going to have? Also, I've seen laws that say things like for access requests, companies should charge for doing access requests. And this, if you want to charge people, not when it's unreasonable, not when it's excessive and stuff like that. If you want to charge people for access requests, that means you're literally discouraging people from actually enforcing their rights. So, and Teki, you're going to address this too, being a former executive director. So, I mean, how do we, what's the impact of things like this? When we know you need to find creative source to generate revenue because you need to continue to run outside the government grants. The government can decide today to turn off the pipeline for funding, and that might, of course, impact your work. So, but when we do it this way, I mean, when you ask people to register, does that genuinely, and I use the word genuinely carefully, genuinely guarantee the compliance with the law?
Actually, I also noticed that the Information Commissioner Office in the UK has data protection fees. And the data protection fees are also to fund its activities.
Yeah, I'm sure.
So,
Apart has a lot to say about ICO.
yeah, ICO. So I think it's a trend that we will observe going forward. And of course, there are many other things that I'm still trying to gather my thoughts around, whether it's in the best interest of data protection to have fees for every processes, for all the processes. For me, I'm also trying to look at it in terms of the impact on terms of ease of doing business. Does it become another bottleneck to ease of doing business for especially African countries? We're usually trying to get up in those ranks and also have easy and business-friendly environment for the young entrepreneurs and startups. So honestly, I'm still thinking about it, whether, okay, I understand the regulator needs to be funded, but I'm also looking at it in terms of the whole aspect of regulation should also not be a hindrance to economics and to growth by now introducing other bottlenecks. Probably maybe it should be one of license, or maybe licenses which are renewed, maybe not annually, maybe biannually. Yeah, I'm still trying to find out.
You're not decided.
Yeah, I'm not yet decided. Yeah.
All right, Teki, over to you, please.
Yeah, Ridwan, will you accept a position in any data protection commission that will not pay you what you're worth? So I really think that we have to situate this conversation appropriately. All of us here know how expensive the experts in this space are. And from my own experience, I think that, you know, having certain kind of fees is very important. Any other format, a data protection regulator trying to source for funding or get grants and all of that makes it even worse, because it even erodes that sense of independence further. Now, the idea of fees is also not to necessarily cripple the industry, but to keep the engine of the institution running. In Ghana, which you raised, I remember our laws made the registration mandatory, and then the registration was biannual. So every 2 years you register. When the board had to consider a decision around the fees, one of the clear things that the board said, recognizing the importance of the registration and how it is almost mandatory, the board took a decision that the fees should not be fees that will inhibit anybody from registering. And so our lowest fee range that we had for the lowest data controller at the time was the equivalent of what we call 100 Ghana cedis. We had, I think, 3 fee ranges, 100 Ghana cedis, which was the lowest anybody would pay for 2 years. And this amount at the time is now even less than $20 for 2 years. And majority of data controllers, especially what we call then, we categorize as the small data controllers. That was what they were paying there. I don't think those fees have been revised or changed since then. The medium data controllers were paid the equivalent of 750. And you would find a chunk of big businesses, even sometimes to banks and other people, paying 750. Today, the value of that amount is probably a little over $100 for 2 years. Then you have the large data controllers that were controlling millions of data records and all of that. And they were paying the equivalent of what was then 1,500 Ghana cedis. Okay, at the time, I think 1,500 Ghana cedis will today be maybe a little under maybe $250 or thereabout, just to give it. And this will go to the categories of large communication service providers and all of that. And I remember when we started pushing our drive for registration and people found out the fees, nobody ever said, oh, these fees were too onerous, right? That is preventing me to register. Indeed, when they find out, initially when they see the push for registration, they think that it is a money-making collection until they realize that, oh, it's not a lot of money. And also we made the registration processes, we made it easy for somebody to just register. So I think that the fees are necessary to keep the engine of the institution running. And so we should look at that, but we should not look at, we should look at the various administrative costs that those processes will cost the regulator, right, to administer and issue a certificate. The certificate is not for free. If we're going to rely on governments for a lot of these, like you rightly noted, we're not going to have the right people. When it comes to compliance and compliance processes, definitely there may be a bit more, and all these things, you have to look at it in terms of the cost that is incurred by the regulator. If they're going to hire even a data protection expert to help them facilitate this, how much is that going to cost them? So we should look at the barest minimum. It shouldn't be looked at as a profit or a wealth amassing venture. But, you know, industry should understand that we need to pay a little bit if we want to own the data protection institutions, whether CSOs, whether industries, as our own, our regulator, and we don't want government interference. I think we should think about resourcing it. And that's one of the fair and I think, you know, best ways to resource these institutions as well, you know. And one of the things we also sought to do that a data protection authority can do to justify some of these fees is to also provide a number of, call them free services that allow those that are paying the money to know that at least they are getting something worth from the regulator, so that, you know, it's not as if I have come to pay money and I'm not getting anything in return, you know.
All right, thank you very much. And I've taken a lot of your time, and I still want us to take questions. But Danielle, let me ask you my final question today. So there's been big arguments around how expensive data protection is to implement for especially small size businesses. And more recently, there was an article published by, I think, Politico, where Alex Voss, a member of the European Parliament, was saying something around the GDPR not being able to, how do I put it, not being able to catch up with the modern challenges. But that's not my concern, to be honest, because I probably have a problem with that particular position myself. But my question is that there's a whole lot of questions, and it comes up every time. Data protection is expensive. How do SMEs and small, how do small and medium-sized businesses, how are they meant to comply? So if you can take that and take that alongside your recommendation, and you can do that for me like 2 minutes. Yeah.
Okay, Ridwan. I would say for any business that the promoter would see growing, not necessarily too fast, but growing the right way, it has to consider some safeguards. It has to consider some issues that are vital to to the growth of the business, that are vital to the future of the business. And having a look at the data protection safeguards in the business promoter's specific sector of activity should be like any other normal thing one should do in his business. That is very important. So there is nothing like this is too expensive when it is vital to the business. Okay, so this has, it is not specific to telecom operators or financial services providers. I mean, in every business that would cover the collection or the use of users' data. It is vital. Having a regulatory check or a due diligence check, kind of regulatory check, even on a yearly basis, it is vital to the business to make sure that throughout the year, the operations are being safeguarded in terms of what should I do, what should I not, what should I avoid to do to make the business stable throughout the year. So if you allocate, let's say, a minimum amount for that to make sure your business is protected from the data privacy perspective, then I think you as the promoter of the business, you are doing what is nothing but normal for the business to be stable and for it to grow the right way. So I don't think for somebody who sees the future as bright as his business, it should consider, issues around it is too expensive to maintain a data privacy regulatory check on a yearly basis. So to me, it is as important as paying taxes, as important as paying employees in a business. You have to run your own check for the business, and data privacy is definitely one of those due diligence that one has to do every year for his business.
Okay, thank you. If I get that, they should tie it to both existence and also their profitability.
Yes.
Okay.
Yes.
Okay. Thank you. Let's see if we can take a few questions there before I let everyone give their recommendations on the way forward. So, part this for you. How do you think the African, specifically Nigerian fintech space, can respond to local statutory requirement and framework while operating internationally and complying with international data protection regulations? Would there be too much conflict or conflicting requirements?
Sorry, can you just repeat that again, Ridwan?
Okay, let me take this again. Okay, so
in the chat?
Yeah, it's within the chat, sent quite early. How do you think the African, specifically Nigerian fintech space, can respond to local statutory requirements and frameworks while operating internationally? And complying with international data protection regulations? Would there be too much conflict or conflicting requirements?
No, I don't think so. What I see in more modern laws in Africa are international baselines, whether that is on Convention 108 Plus or whether they've incorporated key aspects of the GDPR, but there are baseline laws on data protection. But then, of course, even within Africa, you have the financial regulatory framework may not be, to use Teki's point earlier, as harmonized as it requires to be. And that just requires you to, I think, go for the highest standard. But in terms of data protection, certainly there's a Nigerian company that is operating in 2 Eastern European countries. So there's a question in my mind as to whether the NITDA regulation, rather than an omnibus data protection law, appropriately provides rights to data subjects in those European countries, to be honest. Not sure I answered it, but it's difficult to do in a few minutes. But
Yeah, like I said, I mean, wait, too many things to talk about, and the time is just like a constraint. I mean, I've pushed this way above the timeline I mentioned to everyone. So if you want to take your recommendations quickly, what will be your recommendations in, or will I say recommendation plus your prediction next 10 years? What's it going to be like?
Well, I think, very clearly you've got Stripe, who bought out a fintech company, right, in Nigeria. And then you've got, I'm not sure if I have the slides here. Let's have a look. I think I do. You've got a company that's offering services. Yeah. Nigerian fintech targets $1.1 billion in Eastern Europe loans. And that's in Poland and Republic of Czechoslovakia, for example. So there, clearly, they would have to, my recommendation would be look at those laws in that country and adopt your own policy, your own procedures to ensure compliance with those laws, map those regulatory requirements, and then have a look at your own the regulation and to what degree does that impose obligations on you with regards to the individuals in Poland and Czechoslovakia, if I think of those two in that particular instance. And notwithstanding the law, how do you foster trust? What's the level of trust you want? Do you want no trust, or do you want good trust with your customers? And what is it that's going to drive trust with them? But yeah, on law, you've just got to identify the countries you want to operate in and map those legal and regulatory requirements. And just as big companies have to do around the world, it's part and parcel of being a global entity, really.
The last part of it is what's it like next 10 years for the continent? What's the next decade like? Or what do we expect to see in the next decade?
I think what I'm hoping to see is that African countries come together. I think to take Teki's point right at the beginning, I think Africa has such huge potential not to follow the lead of other regions, but to actually come together. There are very genuine needs in Africa to come together on data protection, to have a harmonized framework, both internally within African countries, across borders in Africa, but also externally with the rest of the world. And what I hope is that we see this single market concept develop and flourish, because there are incredible entrepreneurs in Africa. So where do I see it going? I do see African countries coming together. I do see the network of African data protection authorities becoming stronger. Absolutely. And good luck to those involved.
Thank you very much for that. Danielle, well, what's the next 10 years going to be? What's the next decade? What would you like to see in the next decade?
In the next decade, exactly as Pat just mentioned, I think we have all it takes to be the data privacy regulatory hub in the world, because we have a lot in terms of situations, in terms of issues to handle, in terms of how easily these emerging technologies have been adopted in our societies. So I think we have the platform to come up with standards that we would be able to export to the entire world in 10 years. So we just need to keep working on perfecting what we have now in terms of capabilities, in terms of potentialities. That is, the industry is young, but it is very dynamic. As far as emerging technologies is concerned, I think we have shown to the world what did not exist in the past. So we can use that platform to come up with guidelines that some other countries in some other continents in the world would envy us and will copy at the same time. This is where I see us in 10 years.
quite an ambitious one. Thank you for that. Francis.
The next 10 years, my views resonate more with what Pat has just said. I hope there will be more collaboration between data protection authorities. More countries also, basically, I hope all countries eventually get data protection laws. And then also seeing now the development of African jurisprudence in the area of data protection law. So more litigation, maybe cases referred to the Africa court, but I hope to just see more activity in the more legal activity, consciousness among the people, knowing that they have privacy and data protection rights, and then now them taking action whenever there's a violation or whenever they feel like something needs to be done. Them calling out people who are breaching. Yeah, some more accountability and awareness.
Okay, thank you very much. More informed citizens, that would be a really interesting point, because I think when people become aware about the rights that they have, I think it could be a major driver for enforcement as well. Well, if the regulator wants to do their job. Because I typically see parts regularly talking about ICO not doing its job the way it's meant to. So I know Pat has enough to say about this. So, Teki, next 10 years.
So for me, over the next 10 years, I'm actually hoping for more relevant growth. And by relevant growth, I'm not just talking about adoption of laws, but creating of relevant institutions that can facilitate this growth. I want to see a growth in our implementation and enforcement of laws within the data protection space as well. And whilst we're at it, we should also look and have an understanding of the peculiar nature of our continent as Africa, and build bridges that facilitate growth within ourselves as well. So I think that those are the maybe 3 key things that I would really love to see in the next 10 years.
All right, thank you very much. I really don't like to say bye, because it's been a very interesting conversation, and trust me, I still have like a lot of questions that I still intend to ask, but of course, time is not kind. So thank you very much to all the panelists. I'm immensely grateful for sacrificing your time and also being able to extend this beyond what we initially agreed. Thank you, everyone that stayed. Thank you very much. We're very grateful.
Thank you.
And
thank you.
I think this conversation should actually be even a basis of a report, which we'll work on. And of course, we'll get across to each and every one of you to get your input. I mean, I'm really inspired to write something exactly on the topic. And of course, we'll be in touch. I mean, the number of research, I think alternative funding should also be a point of research. Alternative funding for data protection authorities should actually be a point of research. The number of issues that have been, that came up today, I'm really grateful for that. Nurudin, do you want to say, and I've said thank you already, but can you have the final before we say bye to everyone? Okay, I'm not sure Nurudin is on seat.
Hi, Ridwan, sorry. I was struggling to unmute my mic. I think we are in the era of muting and unmuting mics. Hoping that not in the next decades, like all the panelists have mentioned, respect to data protection. I'm hoping by tomorrow, we'll come to an era where we can actually see everybody live. We can be in the same center and having this conversation around data protection, privacy, in the midst of ourselves, and also all the people who are interested in this conversation. But I think it's been a beautiful 1.5 hours or more. Thank you very much for all the wonderful contributions. Like Ridwan said, we might probably need to follow up with you individually with respect to some of the questions and information and more insights that some of the participants on the session have asked us. But I mean, I want to use this opportunity to thank you once again, individually and collectively, for contributing over the past 10 years, right? More than a decade, in data protection, privacy, and more importantly, human rights within Africa and also the rest of the world. I think at this point in time, I will just say, have a beautiful day. I'm hoping you enjoy the rest of the day. And we look forward to more insightful and more meaningful conversation, both on the webinars and looking forward to reading individual thoughts and actions from your respective social media platforms. Thank you very much.
Thank you, Nuruddin.
Thank you, everyone. See you in person someday
Thank you.
soon. Bye.
Yes.
Thank you. Bye.
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 Bye.